absolute decision is your decision, and we cannot stop you if you decided you wanted to testify in this case. Is that correct?
Correct.
And have you thought about it, and did we actually tell you last night to think about it again before we came in this morning, and then wait to hear the rest of the testimony before making that decision?
Yeah.
And have you made that decision on whether you want to testify on your own behalf?
Yes, I have.
And what is that decision, sir?
I'm not testifying.
And you understand they cannot use that against you. You not testifying, and the evidence will be as it is, and we go right into closing argument.
Yes, sir.
Okay. And Mr. Johnson, everything Ms. Martin, myself, Ms. Silva, and Ms. Andrade has done so far, have we kept you abreast of everything, trial strategy, discovery, what we plan on doing in this case?
Yes.
And are you satisfied, or I hope very satisfied the way Ms. Martin has presented her case at this point?
Not satisfied.
Now, any questions, concerns, or anything for the judge or us before we sit down?
No.
Okay. I'll pass the witness, Ryan.
All right. You may be seated, Mr. Johnson. Thank you so much. All right. Then how much time would you like to argue? $30?
That's more than.
All right. Will the state open?
Yes, Judge, if you could let me know once I've used 10.
Yes, I can.
Me as well, Your Honor, please.
Okay.
Thank you.
So the defense is going to divide up their time.
Yes,
Ms. Burris, with your remaining time, what kind of warning would you like?
What do I know when I have 2 minutes left?
Yes. And Ms. Martin, would you like a 2-minute warning?
Yes, please.
All right. We've got 2 10s and 2 2s. All right, then we are ready for the jury.
That's what it was.
Mrs. Garza, we're going to have a hearing at 2:30 on the Cortine Walker case.
Okay.
Yes. That's the one with the PDs. And Jay. That's, yeah.
Okay.
It's really just a status hearing, I guess. They've changed it too, but I'm not going to allow them to drag. They will drag this to infinity and beyond. Mm-hmm. We're ready.
All right.
All right, you may be seated. The state having rested, what says the defense? All right, ladies and gentlemen of the jury, well, does the state close?
Yes, Your Honor.
Thank you. All right, ladies and gentlemen of the jury, you've now heard all of the evidence that you are going to in this case. I have prepared the court's charge to the jury. This document has all of the law that you are to apply to the evidence that you've heard in this case. I will now read this to you, and then we will have arguments of counsel. You don't have to memorize what I read to you. This jury charge will go back to the jury room with you. Court's charge to the jury. Members of the jury. The defendant, Cedric Deshawn Johnson, has been charged by indictment with the felony offense of intentionally or knowingly, by omission, causing serious bodily injury to a child alleged to have been committed in Dallas County, Texas, on or about the 10th day of July, 2019. To this charge, the defendant has entered a plea of not guilty. Offense definition. A person commits an offense if he intentionally, knowingly, or recklessly by omission causes a child serious bodily injury. An omission that causes a serious bodily injury is conduct constituting an offense if the actor has a legal or statutory duty to act, or the actor has assumed care, custody, or control of the child. For the purposes of an omission, the actor has assumed care, custody, or control if the actor has, by act, words, or course of conduct, acted so as to cause a reasonable person to conclude that the actor has accepted responsibility for protection, food, shelter, or medical care for a child. Term definitions. Actor means a person who is criminally responsible. Actor means a person whose criminal responsibility is an issue in a criminal action. Person means an individual. Individual means a human being who is alive. Child means a person 14 years of age or younger. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Mental state definitions. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Application paragraph. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 10th day of July, 2019 in Dallas County, Texas, the defendant, Cedric Deshawn Johnson, did unlawfully then and there intentionally or knowingly by omission cause serious bodily injury to C. Jackson, a child 14 years of age or younger, hereinafter called complainant, by failing to seek medical attention, and at the time of the said omission the defendant had a legal or statutory duty to act in behalf of complainant in that the defendant had assumed care, custody, or control of complainant, then you will find the defendant guilty as charged in the indictment. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of intentionally or knowingly by omission causing serious bodily injury to a child as alleged in the indictment, and proceed to consider whether the defendant is guilty of the lesser included offense of recklessly by omission causing serious bodily injury to a child, as included in the indictment. Lesser included offense. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 10th day of July 2019 in Dallas County, Texas, the defendant, Cedric Deshawn Johnson, did unlawfully then and there recklessly, by omission, cause serious bodily injury to C. Jackson, a child 14 years of age or younger, hereinafter called complainant, by failing to seek medical attention, and at the time of the said omission, the defendant had a legal or statutory duty to act in behalf of complainant, in that the defendant had assumed care, custody, or control of the complainant, then you will find the defendant guilty of the lesser included offense of recklessly by omission causing serious bodily injury to a child, as included in the indictment. If you believe from the evidence beyond a reasonable doubt that the defendant is guilty of either intentionally or knowingly by omission causing serious bodily injury to a child, as alleged in the indictment, or recklessly by omission causing serious bodily injury to a child, as included in the indictment, but you have a reasonable doubt as to which of the said offenses he is guilty, then you must resolve that doubt in the defendant's favor and find him guilty of the lesser offense of recklessly by omission causing serious bodily injury to a child, as included in the indictment. If you have a reasonable doubt as to whether the defendant is guilty of any offense defined in this charge, then you will acquit the defendant and say by your verdict, not guilty. Fifth Amendment right. Our law provides that a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. Indictment. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. The fact that a person has been arrested, confined, indicted for, or otherwise charged with an offense does not give rise to any inference of guilt at his trial. Presumption of innocence. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. Excuse me, I saw a typo. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after a careful and impartial consideration of all the evidence in the case. Burden of proof. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event that you in the event you have a reasonable doubt as to the defendant's guilt after considering all of the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Extraneous offenses. You are instructed that if there is any evidence before you in this case regarding the defendant's having committed any offense other than the offense alleged against him in the indictment in this case, you cannot consider said evidence for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense, if any. Even then, you may only consider the same in determining the state of mind of the defendant, motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident of the defendant, if any, in connection with the offense alleged against him in the indictment. Instruction on defendant's statement. You are instructed that under our law, a confession of a defendant made while the defendant was in jail or place of confinement or in custody of an officer shall be admissible in evidence if it appears that the same was freely and voluntarily made, without compulsion or persuasion. However, before a statement made orally to law enforcement or persons acting as agents of law enforcement may be considered voluntary, it must be shown beyond a reasonable doubt that prior to making such statement, the accused was warned by the person to whom the statement was made or by a magistrate that he has the right to remain silent and not make any statement at all and that any statement he makes may be used against him at his trial, that any statement he makes may be used as evidence against him in court, that he has a right to have a lawyer present to advise him prior to and during any questioning, that if he is unable to employ a lawyer, he has the right to have a lawyer appointed to him to advise him prior to and during any questioning, and that he has the right to terminate the interview at any time, and that prior to and during the making of the statement, the accused knowingly, intelligently, and voluntarily waived the rights set out above. So, if you find from the evidence, or if you have a reasonable doubt thereof, that before making the statement to Detective Rico Harris on July 11, 2019, the defendant requested to speak with a lawyer and did not thereafter knowingly, intelligently, or voluntarily waive his right to counsel, then you shall disregard such statement and not consider it for any purpose, nor any evidence obtained as a result thereof. Instruction regarding bias. You are instructed that jurors must be able and willing to make careful and impartial decisions that are not based on bias or prejudice. Do not let any personal bias, prejudice, sympathy, or resentment on your part, or any such personal emotion on your part, enter your deliberations or affect your verdict in this case. All persons deserve fair treatment and equal justice under the law, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You must set aside your own personal biases and prejudices during your deliberations and base your verdict on the evidence. Decisions based, either wholly or in part, on unfair stereotypes have no place in a criminal trial and will taint any verdict which is not based solely on the evidence and these instructions. Evidentiary instructions. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted. You are not to be concerned with the reasons for such rulings and are not to draw any inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court neither determines what weight should be given such evidence nor passes on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you, of course, must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. Deliberation instructions. After you retire to the jury room, you should select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify your verdict by using the appropriate form attached hereto and signing the same as presiding juror. Your verdict must be unanimous and shall be arrived at by due deliberation and not by majority vote or method of chance. It is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he or she may have heard regarding the case from any other source than the witness stand. You are instructed that any statements of counsel made during the course of the trial or during argument not supported by the evidence, or statements of law made by counsel not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider or mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. During your deliberations, you are also instructed you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, such as Facebook, Snapchat, LinkedIn, YouTube, Instagram, TikTok, or X, formerly Twitter, to communicate to anyone any information about this case or conduct any research about this case until I accept your verdict, if any. If members of the jury disagree about the statement of any witness, the court reporter will read back to you certain testimony. The court will allow the court reporter to do this only if you submit in writing to the court, signed by the foreperson, that one states that the members of the jury have a disagreement about a specific statement of a witness, 2, identifies the witness who made the statement, and 3, requests the testimony to be read back. The court will then have the court reporter read back only that part of the statement that the members of the jury disagree about. After you have retired to consider your verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with this court in writing, signed by your presiding juror, through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any question you may have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this cause, and restrict your deliberations solely to the issue of guilt or innocence of the defendant. If you have a verdict, or if you wish to take a break, turn on the red light and the bailiff will quickly respond. Signed by me, Nancy Mulder, Judge of Criminal District Court 6. The next page has the verdict forms. They read as follows. We, the jury, unanimously find the defendant, Cedric Deshawn Johnson, guilty of intentionally or knowingly by omission causing serious bodily injury to a child as charged in the indictment. There's a place for the presiding juror to sign and then print his or her name. Or, we, the jury, unanimously find the defendant, Cedric Deshawn Johnson, guilty of recklessly by omission causing serious bodily injury to a child as included in the indictment. And the last verdict form on the last page reads, we, the jury, unanimously find the defendant, Cedric Deshawn Johnson, not guilty. We will now have arguments of counsel. Will the state open?
Yes, please, Your Honor.
You may proceed.
May it please the court,
Yes.
opposing counsel, members of the jury. When I talked to you guys on Monday, I obviously couldn't give you guys the facts of the case. But we're here today on an injury to a child case by omission, where that's our victim, CJ. We're here to get justice for CJ today. So let's talk about what we talked about on Monday. I told you guys that left side is where we were on Monday. We're now on that right side, right? We're now on that part where you have an oath to follow the law. The law is going to be given to you in this packet. The judge is going to give you. She'll give you your own. This one I've written all over. So you'll get your own. Okay? The laws are what's going to govern. You're going to have to be able to set your biases and prejudices aside and follow the law in this case. And we're going to be asking you to do that. We talked about beyond a reasonable doubt. We talked about how not every piece is going to be filled in. We talked about how you guys could still find beyond a reasonable doubt without all the pieces in place. I also talked to you guys about what it is that we actually had to prove when we were making those cookies, right? These are the elements we had to make, right? It's the defendant, Cedric Deshawn Johnson, on or about July 10th, 2019, in Dallas County. Remember that address we were talking about every time. I know y'all are probably sick of us asking, is that in Dallas County? Is that in the state of Texas? That's every second I come up here right now and tell you guys. Y'all heard it was in Dallas County. It was in the state of Texas. Intentionally or knowingly. So let's talk about that. Remember what the example was I gave y'all when intentionally and knowingly. He isn't on the jury anymore, but remember I walked up to that first person and I shook his hand, right? That was me having intent. And I told you guys it can be formed in an instant, right? It can go from I was going to do this and instead I'm doing this now because I changed my mind. And it can also be inferred based on the actions before, during, and after the event, right? It's stuff that you guys will consider the actions that you took before, during, and after, right? We talked about it. What is intentionally, what is knowingly, what is recklessly? Intentionally was, I intend to break that top plate with the hammer, right? I know the rest of those plates are going to break when I put that sledgehammer through those plates, right? In this case, what is it? Cedric Deshaun Johnson should have sought medical attention for CJ. He knew that. He was taking care of CJ. We know that because he said so himself. So did Zion. So did other people. He was the one taking care of that child too. Crystal would go to work, he was taking care. Crystal's asleep, he was the one taking care. He would give milk, he would give food, he would clothe that baby, he would take care of that baby. Zion said it, he was the only one who was taking care of that baby. None of the kids were taking care of him, just him. He was the adult in that situation, taking care of those children. We talked about intentionally, knowingly, recklessly. Remember what recklessly is, folks. Recklessly is, I take a hammer and I throw it into the crowd. That's not what this was. This was, I am going to intentionally put this baby into a dumpster. I intended to put this baby into a dumpster. Did I intend to kill this baby? We don't have to prove that. Is there anywhere on there, I intended to kill this baby on there? No. Right? That's not the intent that we have to prove. He did the intentional act of, instead of seeking medical attention, he intentionally put this baby into the dumpster. And he knew the actions of putting a baby in a dumpster is that baby is going to be seriously injured. Serious bodily injury, as we recall, is permanent disfigurement, protracted loss of use, or death. And that's what we have here. You put a baby in a dumpster, there's only one result. Unless by miracle of miracles, someone in the middle of the night happens to come by and hear a baby crying in the middle of the night. Because it wasn't like it was broad daylight, he went out there where somebody might have known. It's not like he put that baby in front of a fire station saying, hopefully someone will go. It's not like he took the baby to a hospital, which is what he said he was going to do. In his mind, he said it in the statement, I thought about going to the hospital. I just didn't know what to tell him. I didn't know what to tell him. Not put the baby in a dumpster. You know, we talk about what's a reasonable thing to do. And this verse is trying to ask that question, would a reasonable person do this? Really, we want you guys to think about it. Would a reasonable person see a baby choking on his own vomit, spitting up blood? Would that person then say, let me go ahead and take this baby and put him in a dumpster? Is that what a reasonable person would do? Is that what we're supposed to do as adults taking care of children? When we're responsible for them? No. We seek medical attention. Everyone would do that. Yes, Dr. Dinkel said she personally would have done CPR. And then she herself, a medical doctor, would have called for help. Not, hey, somebody come help me, which he could have done. There were 7 other people in that room. Crystal wasn't in the room with him. There were 6 children outside. Could have said, help, someone call 911. Did that happen? No. He said, let me keep this baby concealed and take this baby out of this home and take this baby to a dumpster and leave the baby there. But just to make sure, I'm going to take this baby out of the blanket, and then I'm also going to take the blanket to a separate location down the street some ways and put that blanket in a separate recycling bin just to make sure, because I don't want to be connected to this because my DNA is on this thing. Right? That's what Ms. Ferrer was talking about. The DNA stuff, 1 in 190 million. His DNA, the baby's DNA. We know he did it. He said he did it. There's no question about that. The question is, for you guys, he had assumed care, custody, and control of that child. He had a duty to act on behalf of that child. And he didn't fulfill that duty. That's period. He didn't. He had this child. He knew this child was not well. He put the child in the shower. Yes, he took measures. He tried. If we're to believe his statement as to what he said that night, he tried. But trying by yourself is not good enough. And anybody who has a sick baby knows that. You don't take a sick baby and say, well, I can't fix it, so I guess I'm done. You don't just stop. It's a baby. Okay, a couple other things I wanted to cover with you guys. There is an instruction in here on page 5. It says instruction on defendant's statement. Okay. that statement that we all watched, that hour and a half of statement, remember there's a video that goes for a lot longer than that. It's going to be 9.5 hours of video. Okay? In that video, remember we watched the early part of it where they were talking about, where are my kids, where are my kids? I need a lawyer for my kids. I need a lawyer because we're talking about my kids, right? All that's going on. And then hours and hours later, Rico Harris comes through, interviews him, and at that point, Mirandizes him, right? Remember, he gave him his Miranda warnings, just like he's required to do. So this instruction here is talking about, so if you find the evidence, or if you have reasonable doubt thereof, that before making the statement to Detective Rico Harris on July 11th, the defendant requested to speak with a lawyer and did not thereafter knowingly, intelligently, and voluntarily waive his right to counsel, then you shall disregard such statement. Also keep in mind, when he was asking to talk to a lawyer about his kids, he said, I don't mind talking to y'all. I just want to make sure my kids are okay, right? The issue is not whether he had invoked his right to counsel and didn't get a lawyer. He said he wanted it for his kids. He said, I had no problem talking to y'all. When the issue came back up 6 hours later, he did in fact talk to him, right? That's a fact. Y'all saw the video. Was there coercion? Was he forced to do that? No. He was Mirandized and he gave his statement. Okay? That's what that statement's about. Heard defense say that the baby was already dead. Right? That was one of the things that she said during her opening statement, Ms. Martin. The baby was already dead. Mr. Johnson's medical opinion aside, we don't know that. He knew the baby was alive, according to his own statement, when he said the baby wouldn't stop vomiting and was breathing and was making weird noises when the breathing was happening. And then he tried to do CPR. And they kept clearing the airway and vomit kept coming out. He, his medical opinion aside, does not have all the life-saving measures that a hospital would have. That you would take a baby to when their baby is in distress. Which is what you're supposed to do. Not just swaddle this 18-month-old in a tight knot and hope for the best. You have this baby tightly knotted up while you're still giving him a shower and trying to keep him in the bath to try to get all that vomit out. That's crazy. That's a crazy thing. The thought of that to me is, you have a baby who is dying in your arm, in front of you, and you're like, let me swaddle this baby though. Not let me undo these knots and see if I can do anything. Right?
You have 10 minutes.
Thank you, Judge.
10 minutes, excuse me.
Last thing I wanted to cover is following the law. Okay? Following the law. The law is, did we prove these elements? Did we prove that Cedric Deshaun Johnson, on or about July 10, 2019, in Dallas County, in the state of Texas, intentionally or knowingly, by failing to get medical attention for this baby, caused this baby to die? And he had a duty to act. That's what we had to prove to you, and we did. Please find this man guilty.
All right, thank you. Will the defense open?
Yes, Judge. Please support.
Yes.
Counsel. Ladies and gentlemen of the jury, first thing I'm going to do is thank you. It's been a tough 3 days. I know it's been tough for everybody. I want you to remember when I spoke on Monday that I said I don't envy the position of the 12 or 14 of y'all who are here to listen to this evidence is in. We knew the evidence, both sides. We knew what you guys were going to see when deciding this case. We knew the horrific pictures. We knew the testimony. And we knew that this was going to be a difficult situation for everyone involved. But myself and my good friend Jacob here, we disagree on a lot of things on this case. First off, we disagree whether that baby was alive when my client stopped doing medical treatment. And that's a huge distinction, and I'm going to get to why in a second. But remember this. Remember what I talked about in Rhode Island when I spoke with everybody here, and I said to you, I need you 12 people who get selected in those comfy chairs to be intellectually honest with yourself and look me in the eye and tell me if the state failed to prove its case beyond a reasonable doubt, whether you believe the person did a crime or not, you would hold the state to its verdict. You remember how many times I said that to everybody? I think it was about 30. When I went through each section of what I wanted to talk about, I said, now remember, regardless of how horrific regardless of how you feel personally, your duty at this point is to follow the law. Your duty at that point on Monday was to just tell me the truth. I took all of y'all at your word on it. Every single one of you, I took at your word that you would follow the law. That's why you're sitting in these nice comfy chairs as we talked about. And ladies and gentlemen, the law is pretty clear on this case. This is not an individual whose child or guardian child was dying in front of him and he stood there, did nothing, and just watched. This is an individual who tried to save this child. This is an individual who, at the time, immediately finding out something was wrong, was performing CPR, in his words, for over 30 minutes. Was trying to clear his throat. Was trying to put him in the shower to wake this poor baby up. Is this somebody, and I really want you to concentrate on this, is this somebody that was intentionally trying to harm this child by not calling 911? And I'm going to say that again, and then I'm going to read it to you in the chart. Is this somebody who was intentionally or knowingly trying to harm this child by not calling 911? Because that's what they have to prove. They made this decision on the charging instrument, the indictment in this case. And it's in the chart. And if you remember when I said to you, you'll get a charge, don't remember all these legal definitions, you're going to get to read it right here. And remember, reading it, you have to be able, beyond a reasonable doubt, they have to prove to you that he intentionally or knowingly by omission caused serious bodily injury to C. Jackson by failing to seek medical attention. And at the time of said omission, defendant had a legal statutory duty to act. But no, the only evidence you have in the 2 days of testimony is my client through his statement trying to save this baby. Now, yes, if he has a doctorate and is a PhD and an expert, should he have stopped everything and called 911 and that baby died 5 minutes later? We don't know that. But we're not here to speculate. You're here to answer to yourselves right now is, did he attempt to save that baby? Yes. Did he repeatedly attempt to save that baby? Yes. What they have to prove to you. By not calling 911, it was his desire for that baby to die. Or he was reasonably certain that baby would die by not calling 911. But no, they didn't prove that. And you see, I knew what the evidence would be coming out. That's why, if you remember, I stood up and I said there's also another section to talk about. The reckless thought process. And remember, I defined it to you, and the judge defined it, as I said she would. Someone acts reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. I submit to you it doesn't even get to that. But if you have a debate, if you think to yourselves, I don't know, something happened, we've got to hold him guilty of something, which I pray you don't do, that's about as high as he gets. Because if not, you're going to go back there, and whoever you elect foreman, you're going to have to look at each other and say, it was his desire to not call 911 so that baby would die. That's what they charged. They didn't charge my client with abuse of corpse. He would have met every element for that. I couldn't stand up here and say he didn't. But they didn't charge him. And who does the charging? We said it 17 different times in jury selection. So we have to go with what they charged in this case. And ladies and gentlemen, they charged wrong. I want you to go back there. I want you to ask yourselves, why would they even show you that landfill picture? Why would they show you that autopsy picture? Any relevance in that, in the elements they have to prove in this case? No. It's to inflame you. It's to play on your emotions. They know their case with regards to the facts of the offense, what they're charging, the elements of the offense. They don't have. And you may go back there and you say, you know what? I don't like Mr. Johnson. I don't like what he did afterwards. You know what? Mr. Healy doesn't either. Miss Martin doesn't either. As Miss Martin said in opening statement, we're not here for you to like us. We're not here for you to like him. You're here to follow the law. And the law is clear on this issue. I really ask you to remember what you said in Board Diary and how you talked with me and how you guys promised you would follow the law, even if it meant, remember I gave the example of not guilty versus innocent, or we talked about the Casey Anthony example. Even if you, in your mind, you think something happened, the evidence has to rise to that level of beyond a reasonable doubt, meaning more evidence that would take away your children. And everybody sitting here right now told me they can do that. So when you get back there, you ask yourselves that question. You talk to amongst each other, and you say, by him performing CPR for that long, by him trying to save that baby, by him putting that baby in the shower to wake that baby up, they want you to believe that he was trying to kill that baby by omission, by not calling 911? Or he was certain that result would occur by not calling 911? That's a tremendous stretch. So much so that they bring pictures from a landfill that has zero relevance to the elements in the offense. I want to thank you guys. This is not easy. This is not easy for the 12 of y'all or 14, depending on what happens. You've got to go back there and talk about this. These types of cases are never easy. But when you look at the evidence, the only true verdict based on the evidence is not guilty.
You have 11 and a half minutes. Or wait, I'm sorry, you have 6. My math skills are terrible. He used 8.5. He used 8.5 minutes. So you have the rest. Sorry. Sorry.
Here's what I want to talk about first. Because the prosecutor brought up your instruction about the state. And that's important. Because what you gotta do is make sure that you hold the police accountable. You gotta make them do it right. And we're gonna get to it in a little bit, but there's a lot of stuff that the police didn't do. There's a lot of holes in this case. And it starts with not preserving the scene of that apartment, not knowing for hours who's going in and out. It continues with officers and investigators and CPS and forensic interviewers and all the different law enforcement people not talking to each other and telling little pieces of it. I mean, my husband likes to say he used to be a prosecutor, he used to be a defense attorney. He said, you always want to tell the story right, but you got to tell the story that is right. Not the one you want. Not the one you want to convince people. It's got to be what really happened. And you've got to hold the police to their job. And they didn't do that in this case. And because they didn't do that, you as jurors have to send a message to law enforcement. You have to send a message to law enforcement about that right here, right now. You can't violate somebody's rights, no matter what they did or didn't do. Whether they're guilty or innocent, whether they're not guilty or 100% guilty, you can't violate their rights. And it doesn't matter after that. Because that's what your instruction says. If his statement was not voluntary, then everything from that moment going forward, every piece of evidence going forward, you cannot consider. And if that's the case, then there's no evidence. And that means he must be found not guilty. And that may be hard for you. That may be hard for you. But what I want you to pay attention to is that he gets arrested. He asks for a lawyer. And I'm going to respectfully disagree with what that statement is that he makes after he asks for a lawyer, where he talks about talking. It doesn't matter. 50 years of law enforcement. Detective Hartman emphatically, unwaveringly said, the minute somebody says, I want a lawyer, you shut it down. Even Sergeant Harris said that when he heard it, said, oh no, you can't do that. But then it was like, oh well, if it's about the kids, if it's about that. But the bottom line is that doesn't matter why he's asked for a lawyer. He says he wants a lawyer, and then they put him in handcuffs. And he's in handcuffs for 2 hours in that room, even though they only said he a minute. Not only is he in handcuffs in that room, the door is locked. And there are 2 officers right outside that door. You think that's a voluntary situation? You think there's anything about that that's voluntary? No. No. And he sits there for hours and hours and hours. He asked for a lawyer and they said, too bad, somebody's going to come and talk to you. And then Detective Harris comes in. No matter what happens at that point going forward, the writing is on the wall, his rights are violated, and he knows it doesn't matter what happens next. Because they're going to ask him questions no matter what he says yes or no to. They've already done it. They've already told him they're going to do it. There's no way that that was a voluntary statement. And because of it, everything else is gone. Now, if you don't like that, if you think we gotta, law says you gotta do that, but if you think you can't, let's talk about what else they gave you. What else did the police do for you? They didn't prove their case. They didn't. They didn't prove it. How do you prove that a baby who dies, when he says he just wasn't there, he wasn't there anymore, and their expert says, in her expert opinion, when somebody says that, that means that the person has died. Their expert said that. That phrase means the baby died. And what you also have to remember is Detective Harris and their expert said that his description of what happened was jumbled. And it was mishmash. And there was all kinds of things that they could have asked more about. They could have said, hey, tell me a little bit more, clarify this. They could have asked some questions, but they didn't do that because they were in a rush. They were in such a rush to find the baby. That was the primary focus. The focus wasn't about finding out what happened in that apartment. It wasn't about finding out what exactly went down. It was, we've got to get to that child. And in all of that time that they talked to him, the hours and hours, you know how much time they spent talking to him about what happened? Less than 10 minutes. About 7 minutes. That's it. Is that enough? Is that enough? Because that's really all the evidence you have. 7 minutes of asking questions. 7 minutes of a detective who's rushing through everything to tell this man he's guilty of a first-degree crime. Is that good enough? Because that's what the state has brought you. 7 minutes. There wasn't any actual investigation in this case. They didn't go back to the apartment. They didn't go back and ask him more questions. He was in that car. That video, State's Exhibit, whatever it is, when they're in the car looking for, driving from the station to the dumpster and then to the trash cans, that's an hour and 45 minutes. They could have been talking to him then, but they didn't. No. 7 minutes was enough. This case is so fired up with emotion that they think, oh, this is the way he treated the baby when he put him in the trash. Must be what happened, that he must have killed that baby. He must have made that baby die. But there's no evidence of that. Not a single drop of evidence that that's what happened. Because there's only 7 minutes, we have absolutely no idea what happened in that apartment. And and Detective Harris agreed with me. Dr. Daigle said, I don't know what happened. I don't know how this baby died. The medical examiner, Dr. Barnard, said there's no way to tell what happened to this baby. So it's a whole bunch of speculation. It's a whole bunch of, trust me, I'm the state and I'm telling you this is what it's all about because those pictures are so awful. There was absolutely no reason for you guys to see those pictures. Absolutely no reason. Why did they do that? Think about it. Because they want you to focus so much on what happened after the fact, which the landfill man who came in here and talked to you, Richard, he said no one would have any idea that that's what would happen. No one would have any idea. And remember what he said in his voluntary, and I put that in quotes for the record, and a lot of sarcasm, is that he was terrified. He was terrified of CPS because he knew that because the baby had died, something was going to happen to the rest of the kids. Crystal was going to get in trouble. He was going to get in trouble from CPS. Remember that. Because they want you to focus on the emotion, they don't want you to look at the facts. Now, Mr. Zachariah put up the puzzle pieces. I want you to remember, there's a big difference between that shark puzzle, where it's missing 3 pieces, which is what they want you to think this case is all about, than that first puzzle slide that he gave you in Ward Dyer that only had 3 pieces and you couldn't tell what anything was. And unfortunately, you do not have that shark slide in this case. And what did I tell y'all? There's no slide. You're missing a very key piece in that indictment. So, I want to make sure you understand something because this is important. Because these things can be kind of confusing. Lots of words in this document that you're going to go back to. Now, what it says is, and like Mr. Healy said, I don't think they got there at all. But if you're debating about, like Mr. Healy said, this is so awful. I hate what happened so much that I gotta do something. I gotta find him guilty of something. But you're trying to decide, is it, well, we know it's not intentional. Is it knowingly? Is it reckless? I don't know which one it is. This document says if you all are debating which one, you have to give them the benefit of the doubt. You have to go with the lesser. Remember, tie goes to the runner, as the judge said. It goes down to the reckless. Okay? So if you're debating that, you have to go with reckless. Now, here's the other thing. If you're debating any of those things, whether they've proven any of those things, then I'm going to submit to you that they haven't proven any mental state, which is an element that they have to prove, and you all have a reasonable doubt as to that, and that means he's not guilty. I'll say it again, because that was a little bit wordy. If you are debating, did they prove intentional? Did they prove reckless? Did they prove knowing? I don't know. I don't know what it is. I don't know if there's anything. That's reasonable doubt. And that's not guilty. Okay? Now, there's no evidence of any kind, that this man intended that this baby die because he didn't call 911 or seek medical attention. There's no evidence at all that he knew not calling for 911 or seeking medical attention was going to result in that baby's death. You have to remember the way he, in those 7 minutes that they were asking him questions, how he was describing it. He was so worked up that he could barely string words together. And we all know that they were all over the place. There's absolutely no way they proved beyond a reasonable doubt, much less anything, that either one of those things happened. And what I think that is important is that Mr. Zachariah said he should have known. Well, guess what? That's not even an element of reckless. So if he should have known, that's a not guilty too. Okay? They chose to charge him with this case. They chose to seek a conviction with these facts applied to this law. And like Mr. Healy said, that's not what he did. What they have proven beyond a reasonable doubt is an intent for the courts. And I told y'all weren't gonna like him. I told y'all that y'all may hate him. Shoot, you may hate me for making you do this. But it's not me making you do it, it's the law. The law is making you find him not guilty. You all made a promise. I told you yesterday morning. You all made a promise. And I told you probably weren't going to like the promise after you heard all the evidence. You may not even like yourself for what you got to do. What you got to do. They did not prove their case. Much less beyond reason. You must. The law requires. And you swore an oath that you will find not guilty.
Thank you, Ms. Martin. Ms. Burris, you have 19 minutes.
Thank you, Aaron. It was work. Counsel. Saying it doesn't make it so. The reality is the reality. As much as they don't want to talk about it, they don't want to face it. The reality is exactly what I promised you yesterday morning. Cedric Jackson Jr., CJ, was supposed to be being cared for by Crystal Jackson. Now you all know Crystal's lying, everybody's lying, and CJ was in fact at home with a total of 9. And I told you that I have no idea what happened to CJ on July 10th, 2019. I still don't. Because I don't know what the defendant did prior to his version of events where he is throwing up, unable to clear his airway, and he has to perform CPR. I don't know what happened to CJ because the defendant chose not to do anything when an 18-month-old is throwing up, can't clear his airway, is making these sounds, and he feels the need to perform CPR for 30 to 40 minutes. And that's why those photos were important to show you. They're awful, they're horrible, I wish I'd never seen them myself. But it was important for you to understand why I can't explain some things to you, that I wish that I could. That I cannot tell you a full story. It is not the lack of investigation, as they want you to claim, because you heard about the investigation they did on the lie that they started with, right? That Harold was the one who was at fault. They already told you they did all that. You heard all about all the law enforcement agencies and all the people who were involved. But yeah, we want to claim there was no investigation. All right, sure. Sure, let's go with that. There is no way for me to tell you other than by putting the pieces together. So what I know happened that is that CJ became distressed. So much so that he required intervention. What I know is that CJ's blood is on the bed, the pillow.
No, that's a misstatement of the evidence. It was DNA.
Overruled. The jury will recall the evidence as they heard it.
The pillow, and the door. That swab on the door that is far above where an 18-month-old could reach. CJ didn't put it there. Came from somewhere. Came from someone who had the ability to reach on the top of that closet door and release CJ's blood. Ladies and gentlemen, we kept asking reasonable because that's the standard. What does a reasonable person do in the defendant's shoes? That's the question. A reasonable person who is in front of anyone who is throwing up and requires CPR calls 911, asks for help. They don't wrap him in a blanket. Think about taking him to the hospital, but instead put him in a dumpster. My 8-year-old knows to call 911. But I'm supposed to believe that because a 28-year-old man was fearful of CPS, he's not calling 911 to assist a baby. Wishing it, saying it, doesn't make it so. Let's talk about his statement. The defense wants you to disregard it, because it's bad for him, because he didn't do it voluntarily. Let's look at it. That's why that conversation is so important. All 9 hours of that recording or evidence, you're more than welcome to look at it if you need to. The conversation in the hallway, you all heard it, but I'm going to say it again. Who says they were there? They did. What criminal offense? What are you talking about? I didn't do that to nobody. I need to talk to a lawyer. Okay, but you have to sit in that room. I don't mind talking to nobody so long as I know my kids are okay. That's the invitation they want you to believe is occurring. It's about his kids. It's absolutely about his kids. He wasn't under any investigation at that time. No one even confirmed that he was there at the time that happens. But if you want further proof, keep watching. He is placed in handcuffs. He's under arrest. Of course he is. But watch the video and take the handcuffs off. And he is so bothered by all of this. It's so upsetting and it's so coercive and it's such a terrible environment for him. He sleeps for hours. Snoring away on the floor. He ain't got a care in the world. He's so bothered by the coercive environment that he's in that he offers without prompting to take the police where he dumped the stuff. But he was so coerced by all of that. Saying it doesn't make it so lazy. And I guess we're supposed to also be upset that the detective didn't allow him to say more. He had hours to say something. But he kept with the lie. Detective Harris listens to that lie for 40 minutes. We go back and watch it. He finally interrupts him, like, I don't care all the CPS stuff, man. I'm looking for CJ. I'm looking for a baby. And you're talking about nonsense. And then he breaks down and he says, he kept making these sounds. I unswallowed him. He started throwing up and I was doing CPR. I was breathing in his mouth and doing compressions. He started throwing up some more. I started breathing in his mouth some more. Stuck my hand in his throat, trying to get the stuff out. It was like throw up. It was not like blood, like yellow, maybe a little red. I kept breathing in his mouth. I didn't do anything to him. There's a discussion about the blanket, what color it was. I don't want somebody to get in trouble because she didn't nobody did nothing. I tried. I did for 30 to 40 minutes. Do you remember what time it was? It was like 12 something. So you was giving him CPR at 12 something for 30 to 40 minutes. Okay, listen to me. Where is he now? I panicked. I put him in the shower, ran the water over to wake him up. His chest was inflated. Put my hand on his chest. I could hear his heart still beating. It demonstrates contractions. Still trying to help him. He wasn't there no more. I started out with CPR in the bedroom on the floor, but he threw up, and then I'm doing it. I'm trying to help him, so I push on his stomach a little bit. That's when the throw up started coming out of his mouth. So I keep with the compressions, breathing so you can get it all. But he's still throwing up. So I take him to the shower, get the cold water, trying to wake him up. The only thing that was working was his heart. It was still beating. I wrapped him in a blanket. I got in the car, and I put him right next to me on the seat. Moving forward a little bit. Thought about taking him to the hospital, but I was like, I don't know what to tell him. I went down Walnut, and I put him in the couch. "30 to 40 minutes. You intended and you knew that every moment that you're working on this baby, trying to save this baby's life in their words, you're not doing anything. He's not getting better. You intentionally and knew that by not calling for medical assistance, there was no outcome for that baby but death. There is no outcome where CJ is alive if you do not ask for medical intervention. If your CPR isn't working, that's what's happening. And therefore, you intended and you knew that this baby was going to die. You chose not to take him to a hospital. You chose not to call 911. You chose not to ask the other 8 people in the home with you if they can help you. You put him in a dumpster like he's garbage. In her opening statement, Ms. Martin said to you, what is he supposed to do? Call 911! Go next door, get help, anything. Drive to a hospital. That is what any other reasonable person does in the defendant's shoes. Nothing. Mr. Zacharias spent some time with what I are talking to you guys about those different mens reas, those mental states, as we call them. If you want to believe that a 28-year-old man who has already had interference with CPS, has several children of his own, if you want to believe that he didn't know what was going to happen with this kid, then I've got some oceanfront property in Arizona for you. It's preposterous. It's ridiculous. Saying doesn't make it so. Wishing for it doesn't make it so. The law is incredibly clear. His actions, his intentional, knowing actions, are the reason that CJ is not alive. Bottom line, it's as clear as that. Wishing can't take it away, hoping can't take it away. The defendant is the one who is the reason that CJ doesn't get to see his mom, that Latricia doesn't get to hug her grandbaby. His actions. His intentional and knowing actions. There is no other verdict in this case but guilty. Today is the day for justice for CJ. He and his family have been waiting 6 years for this. It is time. It is the day that Cedric Deshawn Johnson is finally told by a jury. You, sir, you are the reason that CJ, that beautiful 18-month-old boy, is dead. And you should have done something to stop it. You should have sought medical attention for that baby. Find you guilty.
Thank you, ladies and gentlemen of the jury. You will now retire to the jury room, select your presiding juror, and begin your deliberations. For the 2 alternates, you will be placed in a jury room next door, but you 2 cannot discuss the evidence.
All right.
All right. All right, you may be seated. Turn out at 2:57. Come on up. Thank you all very much. Yes.
Where were we talking?
Yes, ma'am. Hello. Oh, no.
Yeah, kicked out the boarding school, it's not med compliant, he's just able, so.
Not really. Not really.
Thank you, ma'am. Thank you. All right, I'm going to run to the restroom. And then we can do Courtine Walker.
Did he get it? I remember those days. I remember. He's been good. See you guys later.
No, she's gonna come out in a second.
Now get up. Thank you. All right. Hello. Do you want to go ahead and get Jay Worley? Thank you. Okay. Great. Great. Excuse me. 1 second. Let me.